We're now moving from Article 6, dealing with SPAs and special areas of conservation, to Article 12, and this is really some musings on Article 12 in the light of the first case which came before the English and Welsh Supreme Court at the very end of last year, a case called Morge. Now, I've a couple of sadnesses. The first, that I shan't be here for the drinks reception this evening, but I'm even sadder about the fact that when I said I'd give this talk, I thought I was going to win a particular case, and in fact I lost it, and I think I've set back the cause of the strict protection of protected species in England and Wales by quite a long way, and rather curiously, I think you here in Ireland are now rather ahead of us. Now, the case was concerned with a new busway just close to Portsmouth, and it ran from Fareham to Gosport, the entire busway, but the first 4 kilometres of it went down a wooded corridor between houses, which it was then proposed to convert, take up old railway track and convert it into a new road as a busway. Inevitably, this involved the removal of trees and disruption of the present habitat for bats. It was granted planning permission by the promoters of the scheme with some regard to bats, but without any express reference to Article 12 and the obligations to protected species which accordingly provided. And I thought we had a pretty clear case for saying that the matter must go back to square one and be reconsidered. As I say, I proved to be wrong. I think it's fair to say that the court felt that the scheme was already at an advanced stage, that many of the trees had already come down, and why should a single person be able to challenge what was thought by some to be a desirable scheme? But I don't think any of those matters should have been relevant if one is to have a strict protection of species. Now, just a little bit by way of background, and this may be rather basic for some of you, but just a reminder that in the Lisbon Treaty and under Article 191 now, the Union policy does stress, very importantly, that the protection of the quality of the environment really does matter, and we've got the precautionary principle and so forth well spelled out. And turning to the Habitats Directive, of course, the aim is to ensure biodiversity through the conservation of wild fauna, etc. A particular definition there of biodiversity by the Commission on Biodiversity, and Article 1A of the directive reminds us that that is measures to maintain or restore the populations of species at a favourable level. Now, the bats with which I was concerned were in the long list in Annex 4A, and of course you in Ireland have had much litigation involved with bats, and they featured pretty strongly in Commission Against Ireland, the Habitats case. I rather like the article, which some of you may have read, by someone in MacDonald about the situation in Ireland, which has the lovely title, "Have We All Gone Bats?" As a result of our concern for bats. And of course we've got this twofold system. Article 12, basically pretty strict protection, and then Article 16 with the derogations. And I just remind you the 4 heads of Article 12, and in the prefatory words, it does say a system of strict protection. And I'll come to look at this in a moment. And then Article 16 is the derogations. And there, of course, if there's no satisfactory alternative, you can't get going at all. And if what you're proposing is going to be detrimental to the maintenance of the population at a favourable conservation status, you don't get going at all. And then there are the various derogations, and I set out these in some length in my paper, but I haven't got time to deal with it now. Just a reminder to you of Commission against Finland, where they had granted an excessive number of licenses to kill wolves, and they hadn't sufficiently targeted the licenses to the threat to lambs and other animals from the wolves. And the ECJ stressed the fact that you only have derogations in exceptional circumstances. You must interpret the Article 16 derogations narrowly, and it's the onus is on the member state to prove that the necessary conditions are made out, reasons must be given, and of course there has to be a report back to the Commission in respect of all derogations which are granted. Those of you who've recently reread Commission against Ireland will remember that the question of derogations was one of the problems here as well. Now, come to Article 12 in a little bit more detail. First of all, just a reminder that in A, B, and C, the action has to be deliberate. But the word deliberate does not mean that which I think an ordinary English or Irish lawyer would understand by deliberate, because it is wider. It is not just that you intend the act, but that you at the very least accept the possibility of the consequence. We in England and Wales would term this the concept of recklessness, and it broadens very considerably the ambit of A, B, and C. It doesn't apply to D because there's never a requirement that it be deliberate there. And so the person who is walking along and accidentally treads on the breeding site, well, I was going to say of an adder, but you don't, of course, have those creatures here, thanks to St. Patrick, but you tread on the breeding site of a European protected species, and you commit the offence automatically. It doesn't even have to be deliberate. Second concept, in the wild, which you have in A and C, and still, I think, unexplored as to quite what in the wild means. I mean, I don't know, when you're out on heathland, probably you are in the wild. What if you're out in a cultivated field? Are you in the wild? To be in the wild, does the land have to be under the control of someone? If one has some bats which are roosting in your stable block, are they in the wild or not? I don't know. These, I think, are unanswered questions. Moving on to breeding sites or resting places, the courts in England have pointed out in the course of the litigation I've been involved in that, of course, the unusual feature of item D is that it really is directed at the habitat rather than the species, because A, B, and C are concerned with the species rather than the habitat. And of course, do remember that in the case of D, as well as the others, indirect effects matters. I just draw to your attention Commission against France. You have to be able to read French to be able to cope with it, and so far there's only Advocate General Cocott's opinion. But I think it is an interesting case to watch, in which the Commission are saying that one should be taking into account of potential sites as well as existing sites, although Advocate General Cocott's view is that that is wrong and it's confined to those sites. It's all about the grand hamster, and as I say, it'll be interesting to see what happens in that particular litigation. Well, then I come back to 12.1b, which is what I was concerned of in my Morge litigation about the busway. The disturbance has got to be deliberate, but in my case, there had already been a bat survey, and everyone knew that if the scheme went ahead, it was going to have effects on bats. So it could not be argued that it was not going to be deliberate disturbance. A feature of B, which you'll see looking at it, that is that it's distinguished from A in that category A is about specimens of the species, whereas B is about disturbance of the species. For my own part, I think that this is an insignificant matter, but the England-Wales Supreme Court thought it was a highly significant matter. I mean, it seems to me not at all surprising that in A, you're not going to go out and capture the species. You're going to go out and capture a specimen of the species. But it seems to me very odd that if you deliberately disturb a specimen of the species, it's not enough, and you've got to be actually disturbing a number, and if so, how many? But that is what our Supreme Court has in fact said on the matter. Well, then you see that phrase, particularly during the period of breeding, rearing, and so forth. It's a slight oddity, that, because when you read on in the directive into 12.3, it's perfectly clear that one is not confined to the period of breeding, rearing, hibernation, and migration. So it simply means that if it's during those periods, then it's particularly serious, and therefore in Ireland, for example, you ought to have a particularly severe fine, or a rather higher fine. I don't know, in England and Wales the fines are still ludicrously small, even the maximum, but the important thing is that the word particularly doesn't mean only in. Now note the oddity in 12b. It does not contain the words insofar as disturbance would be significant, whereas in the Berne Convention, from which it was derived, those words did appear. And it's now pretty clear, and certainly we for the first time definitely established this through the Morge litigation, that deliberate disturbance doesn't have to be significant. And I don't think most people appreciate that. Certainly most English lawyers, I think, didn't appreciate it. So in other words, you can have insignificant disturbance which is covered by Article 12.1b. And the Commission has always maintained that, and the Commission guidance on Article 12 makes that point absolutely clear. Just a little reminder, some of you may have gone on your holidays to Zakynthos and seen the wonderful leatherback turtles there. There were notices up which showed that anyone who did any activity on the beach was doing it deliberately. They should have known that it might lead to disturbance, but the activities went ahead, and indeed people went out in their pedalos in the sea, and I regret to have to confess that I've been out on a pedalo and watched the leatherback turtles, but I didn't know about Article 12 at that stage. Now, what is required under Article 12 is that requisite measures be taken to establish a system of strict protection. And in your own famous case, what the ECJ said was that the directive had to be implemented with unquestionable binding force and with specificity. specificity, precision, and clarity, and that legal certainty was crucial. And I and some others are in slight despair about our Supreme Court ruling, because I think legal certainty has in effect been sacrificed, and none of us really quite understand now what disturbance is. A few more quotations from Commission Against Ireland, and you will remember that you lacked the necessary concrete measures, and your system was held to be then incoherent, although I'm sure it's now very much more coordinated and coherent than it was hitherto. At that stage, it was held that various species, in particular horseshoe bats, were subject to disturbances, and that you didn't have the necessary rules to make it possible to prevent that disturbance. But in the Morge litigation, what was at issue were two questions. First of all, what does disturbance mean under Article 12.2 of the directive? And secondly, what's a planning committee got to do when it's considering an application in order to comply with the directive? It being common ground that they had to have regard to the requirements of the directive. And curiously, there was, and as far as I'm aware, there still is, no case, certainly in England and Wales, or that I have traced within the community, which sets out what is meant by disturbance, which is rather an elementary matter if you're trying to apply Article 12.1b. And it's rather important if all these member states are trying to have a system of strict protection for species. Well, the High Court accepted my submission based on a commission document was that all you needed was a certain negative impact likely to be detrimental. And I maintain that that is the appropriate test. But of course I'm wrong, and therefore I merely hope that your courts may so decided, mine having lamentably failed. But I was doing fine at first instance. They got the test right, and then the judge managed to muck up the rest of the ruling and went off the rails, and so I had absolutely perfect grounds of appeal. So I moved onwards. The Court of Appeal in England, and remember we have this three-tier system, whereas you've only got a two-tier system, they were desperate to try and save the decision. They didn't want to stop this busway going ahead, and they could see that if the test was like the High Court one, I was going to win, and they didn't want me to win. That was absolutely clear. So they produced a different definition, and they said that to disturb a protected species, you had to have a detrimental impact which would affect the conservation status of the species at population level. You got to put under threat the long-term distribution and abundance of the population. Now that had never been argued to them, and it was plainly wrong. So I had an absolutely cast iron ground my appeal to advance further to the Supreme Court. And I have no doubt at all that had the Court of Appeal's interpretation been upheld, the Commission would have intervened, and we would have had proceedings against the UK government. Because if that was the test, of course, it would be very rare indeed. I mean, I couldn't argue that the effect on my bats was going to have a detrimental effect on the species at a population level. It was going to have 10 years of quite serious impacts, but there were lots of bats, and my bats weren't the rarest form of bats in any event, that they were Annex 4A ones. So what I said, and I thought it was fairly elementary, was to the Supreme Court, is look, disturbance must mean something. You must, in a phrase, be able to spell out what it means. Well, what I got eventually was that it's a whole series of factors. It's a sort of a lot of considerations you've got to take into account. First of all, it relates to species only, not specimens. Well, that didn't matter. I said, don't worry about that. We've got lots of bats here, so that's irrelevant, and I think they agreed with me that. Then, secondly, they went along with me that it didn't have to be significant, and they agreed that the Court of Appeal had got it wrong. It didn't have to affect the long-term conservation species status of the species. What they said is, though, you've got to have an assessment of the nature and extent of the negative impact of the activity upon the species, and ultimately you've got to reach a judgment as to whether that's sufficient to constitute a disturbance of the species. Now just pause there. That has quite considerable implications, as well as being rather curious. In the first place, it doesn't tell you what is disturbance. It simply tells you you've got to make a judgment, and you've got to make a judgment as to whether it's sufficient, but it doesn't tell you what is sufficient. And I think it means that if you are your whichever body it is in this country who prosecutes, I don't know whether it's the NPWS or who brings the prosecutions, but I think it seems to me they've got to bring expert evidence before the court, listing all these factors and ticking all the boxes and saying, I, Mr. or Mrs. X, have reached a judgment that what's happening is sufficient to constitute a disturbance. And then they said that it was sufficient simply to rely on our natural England, which is your NPWS, to say whether the requirement was engaged. In other words, it was a bit of a cop-out for planning authorities. The biggest cop-out of all was I said, look, if you're not with me, surely this is a matter which has to be referred. And I suspect that Irish lawyers have the problem we face, is that you don't want to make it your primary submission that the law isn't clear. So both sides, of course, say it's absolutely clear, but if they're wrong in saying it's clear, it ought to go to Europe. But in reality, on the question of what is disturbance, plainly it isn't clear, and our three levels of court all reached entirely different views, and so under the doctrine of Act Clare, being a final court, it had automatically to be referred. But it wasn't referred, and it's rather curious reasoning, because the judge, and they all agreed with him, said it seemed to him unrealistic to suppose that the Court of Justice would feel able to provide any greater or different assistance. In other words, we find this horrendously difficult, but we've tried jolly hard, and we're actually cleverer and know more about the sort of situation than the ECJ, so we're not going to try. And I'm afraid to tell you that the English courts have done the same on waste, because there they said that the European Court had produced such unhelpful judgments on waste that there was no longer any point in referring the matter because it wouldn't get any clearer. But there, at any rate, you could say, well, look, you have tried referring it, and they've got it wrong. But this is the sort of issue which had never been referred, and so it really was rather deplorable, I think, that it wasn't referred, and I'm still hopeful that the Commission may take the matter up. Well, the end result was pretty unsatisfactory. Who knows what factors are relevant or irrelevant? Who knows what makes the impact negative? How do you tell when the impact is sufficient or insufficient? And then what happens about the role, finally, of the planning authority? Well, their view was that ultimately it was really a matter to be left to others. And our cleverest of all, our one lady in our Supreme Court, who is, I think, probably the brightest of them all, she said this: the United Kingdom has chosen to implement Article 12 by creating criminal offences. It's not the function of a planning authority to police those offences. Now, you in Ireland will be leaping up and saying, but that's precisely what we did and what we were told in Commission Ireland we couldn't do. And that, in a way, is part of the tragedy, because both sides were agreed in their arguments that the criminal law didn't provide an answer and that you'd got, in a system of strict protection, to intervene at the early stage. And therefore, I didn't cite Commission Against Ireland, and therefore many of the obiter dicta in the case of Morge are in straight conflict with Commission Against Ireland, and that I very much regret. But all I say to everyone is that I think people should read our Supreme Court judgment in Morge, because I think it will be regarded probably as extremely influential in your own legal structure. But do remember to argue that a considerable amount of it was obiter, and that a considerable amount of it was probably wrong, and please, please, please don't let your courts go down the path of weakening the strict protection of protected species, because I passionately believe that it's desperately important. I think that the Habitats Directive is designed to achieve it. I think that both England and Ireland didn't achieve it originally in their transposition. I think generally public opinion still doesn't appreciate the importance of species and how they must prevail over economic development. And as I say, answering the question from England, I would now say that the system of strict protection isn't very strict. Thank you very much.